Law Center. And we are just one of the proud partners that support Public Funds, Public Schools, which you can find at pfps.org. Public Funds, Public Schools is a national campaign that was initiated by the Education Law Center, Munger, Tolles and Olson, LLP, the Southern Poverty Law Center, and the SPLC Action Fund. PFPS strives to ensure that all public funds for education are used to maintain and support public schools. To do that, we at PFPS use a range of tools to protect and to promote public education, and those include litigation, just like the case you may have heard that we filed yesterday against Secretary DeVos, advocacy, and research. So today we are here for the webinar, Something to Lose: How School Voucher Programs Fail to Provide Civil Rights and Constitutional Protections. This is the third in our series of webinars, and they are available, if you've missed the first two, on our website on the advocacy page. And there are more that will be coming. So we urge you, while you're on our website, which you can go to right now, to sign up for the PFPS emails, and you can always get the latest information and news about what else is coming. Just a couple of housekeeping items before we get started. If you have any questions, please drop them in the question and answer box, not the chat box, but the Q&A box. That's the one we will be monitoring to ask them at the end of the presentation. Also, please note that this webinar is being recorded. Today, we are excited, as I know you are, to have Dr. Preston Green III to discuss with us school voucher programs and how these programs fail to provide civil rights and constitutional protections to students. Dr. Green, who holds both a doctorate in education and a Juris Doctorate, is a professor of educational leadership and law at the University of Connecticut. He has published widely on legal and policy issues related to educational access and school privatization. He is passionate about addressing issues of choice and making sure parents and caregivers are educated about what they might lose in making the choice to accept vouchers, specifically what rights children have in public schools that are lost when they transition to private schools. In addition to school choice, Dr. Green is an expert in charter schools, educational equity, education leadership, and educational policy. So I'll turn it over now to Dr. Green, and thank you so much for being here with us today.
Well, I thank you so much as well. I want to thank Public Funds, Public Schools, and the Southern Poverty Law Center for providing me the opportunity to talk to you about this important issue today. And I also thank all of you for attending as well in the audience. So proponents of school choice, school voucher programs proclaim that private school choice is the civil rights issue of the 21st century. Yet the statement fails to consider the civil rights and constitutional protections that parents and students may give up to participate in these voucher programs. So in this webinar, I will lay out the losses of such protections and identify steps that legislators can take to ensure that school voucher programs protect student rights. Next slide, please. So in this webinar, I shall first discuss the various types of voucher programs. Next, I will identify the ways that voucher programs fail to provide federal statutory civil rights protections to students. This will follow with an explanation of how voucher programs fail to protect the constitutional rights of students. Finally, I shall close with recommendations for correcting these deficiencies. Next slide, please. So first let me talk about the types of school voucher programs. So there are three primary approaches for providing public financial support for private schooling. They are vouchers, tuition tax credit scholarships, which are otherwise known as Neovouchers, and education savings accounts, or ESAs. In the next three slides, I shall briefly discuss each funding arrangement. Next slide, please. So vouchers are government-funded coupons or vouchers given to parents or guardians that are redeemable for tuition fees at participating private schools. So according to the clearinghouse or EdChoice, there are 29 voucher programs in 18 states. These programs serve 192,660 students. Next slide, please. Tuition tax credit programs, or Neovouchers, allow taxpayers to receive full or partial tax credits when they donate to nonprofit school tuition organizations, otherwise known as STOs. The STOs in turn package these donations into vouchers that parents can use to pay for private school tuition. According to EdChoice, there are 23 tuition tax credit programs in 18 states. These programs serve 289,260 students. Next slide, please. Education savings accounts, or ESAs, provide governmental funding in the form of a debit card, usually called the savings account. Parents or guardians are authorized to use the funds provided in these accounts for a wide variety of purposes, such as online virtual schooling, private tutoring, higher education, and dual enrollment, and also for private school tuition. There are presently 5 ESA programs in 5 states. According to EdChoice, these programs serve 18,706 students. So a number of proponents have been calling for an increase in school choice programming, and notably for voucher programming. And notably, this past June, even President Donald Trump has adopted the soaring rhetoric of calling civil rights the civil rights issue of our time. And as Mr. Trump specifically stated in June 16, 2020, we're fighting for school choice, which really is the civil rights issue of all time in this country. Frankly, school choice is the civil rights statement of the year, of the decade, and probably beyond, because all children have to have access to quality education. We should be concerned about statements proclaiming that school choice is a civil right. First, there's a historic component to this. As many of you are probably aware, many Southern states used voucher programs to circumvent school desegregation decrees in the wake of Brown v. Board of Education. In fact, the Supreme Court eventually declared the strategy unconstitutional in the case Griffin versus County School Board of Prince Edward County. Second, this idea of school choice being a civil right includes an unstated trade-off, as it were. In exchange for choice, students lose many of the rights and protections that they have in public schools. Next slide, please. So, what rights do voucher students lose? So, they lose some of the protections provided by federal civil rights statutes that are designed to protect students from discrimination. They also may lose important protections under the US Constitution that are guaranteed for public students. So in the next few slides, I shall go into more detail about the possible loss of protections. Next slide, please. So this slide, titled Statutes, Race, National Origin, and English Learners, compares the statutory protections prohibiting discrimination on the basis of race, national origin, and English language learning. The left column identifies the federal statutory protections provided to public school students. The middle column identifies the federal statutory protections provided to private school students. And finally, the right column identifies the protections provided by voucher schools under state voucher law. So when I use the term voucher school, I am focusing on voucher programs. Now, if you look to the left column, you'll find that public school students receive protections through Title VI of the Title VI and the Equal Education Opportunity Act, or otherwise known as EEOA. Title VI prohibits discrimination on the basis of race, color, and national origin. The EEOA provides protections for English learners, specifically requires states and local school districts to take appropriate action to overcome language barriers that impede equal participation by its students in its instructional programs. Federal statutory law provides some protection for private school students. Notably, 42 USC section 1981, an old Civil War statute, prohibits private schools from discriminating on the basis of race in the forming of contracts. Now, there is some question over whether section 1981 applies to religious schools, but just note that there is protection with respect to race, but also note that there is no mention or statutory protection for English learners, similar to what EEOA provides for public schools. Now, going to the right column, we note that most voucher statutes remove all doubt about racial discrimination by explicitly prohibiting such action. However, please note that neither federal law applying to private schools nor state law applying to vouchers provides protections for English learners. Next slide, please. So this slide identifies statutory civil rights protections with respect to sex. Public schools must comply with Title IX, a statute that prohibits recipients of federal funds from discriminating on the basis of sex. Now, it's important to note that statutory regulations do permit single-sex schools to exist. Now, although Title IX does not explicitly prohibit discrimination on the basis of sexual orientation, courts and the Office for Civil Rights have recognized that Title IX applies to this type of discrimination. Now, the Obama administration went even further to interpret Title IX regulations to extend to transgender students, but the Trump administration has rescinded this coverage. Now, with respect to private schools, Title IX only applies to schools that receive federal funding. Furthermore, Title IX has a religious exemption, so religious schools are not covered even if they receive federal funding. Finally, as Julie Mead, Suzanne Eckes, and Jessica Ohm have noted in their thorough review of voucher programs, voucher statutes are generally silent with respect to sex discrimination. Indeed, they find that only the Washington, D.C. program explicitly prohibits sex discrimination. Next slide, please. So this slide discusses the statutory protections provided to students with disabilities. So public school students receive protection through Section 504 of the Rehabilitation Act of 1973. They also receive protection through the American Disabilities Act, or ADA, of 1990, and also the Individuals with Disabilities Education Act, or IDEA. Now, Section 504 requires recipients of federal funding to provide non-discriminatory access to students with disabilities in all their programming. The ADA imposes this non-discriminatory requirement on entities that receive public accommodations. So this language does include private schools. Now, a word about the IDEA. Now, the IDEA is not a civil rights law per se, but it is rather an education law that is designed specifically to address the education needs of students with disabilities. However, I believe that it is an important law to discuss because it impacts on the quality of education that students with disabilities receive. Now, this statute requires public schools to provide students with disabilities a free, appropriate public education, otherwise known as FAPE, and it also requires related services to meet their needs. Now, with respect to private schools, note that Section 504 only applies to schools that receive federal funding. While the ADA does apply to private schools, the statute explicitly exempts religious schools. And with respect to voucher schools, Suzanne Eckes, Julie Mead, and Jessica Ohm discovered in their review of voucher programs that 13 out of 25 voucher statutes had targeted students with disabilities. So they were specifically addressed to provide students with disabilities access to voucher schools. But setting aside these programs, Eckes and colleagues further found that voucher programs rarely included provisions that address students with disabilities. And indeed, these researchers found that a few voucher statutes declared that students voluntarily waived their right to FAPE by participating in that state's voucher program. Next slide, please. So in addition to the civil rights statutes that I just covered, there are several constitutional provisions that are important for student rights. So as the Supreme Court has stated, student rights do not shed their constitutional rights at the schoolhouse gate. And I should also, before going into the specific constitutional provisions, just provide a historic note that, through litigation over the years, organizations such as the NAACP Legal Defense Fund used arguments to enable students, such as Black students, the ability to participate in public schooling. So this is a long fought effort through, to use these constitutional provisions to enable students to obtain educational access. So there are 4 constitutional protections that I will quickly go over that are important to student rights. The first provisions are the Establishment Clause and the Free Exercise Clause. So for our purposes, among other things, these constitutional provisions prohibit the government from discriminating on the basis of religious belief. And a key case to understand this importance is Zellman versus Simmons-Harris. This is a 2002 case in which the Supreme Court ruled that Cleveland's voucher program did not violate the Establishment Clause, in part because the voucher statute explicitly prohibited participants from discriminating on the basis of religion. Next slide, please. So, as I've said before, I'm very, very interested and very concerned about whether voucher programs provide protections to students. And first, it's important to know that even though the Zellman case specifically referenced Ohio's non-discriminatory provisions, Suzanne Eckes and colleagues observed that most voucher programs are silent on this issue of religious discrimination. Indeed, several statutes explicitly permit schools to consider religious criteria during admission. Furthermore, voucher statutes are quiet with respect to equal protection and, with respect to the constitutional provisions of equal protection and due process. Now, One thing I forgot to talk about, if you go back to the previous slide about the 14th Amendment, I do want to mention that the 14th Amendment includes the Due Process Clause and the Equal Protection Clause. So the Due Process Clause is an important provision that provides public school students with notice and an opportunity to be heard when a public school wishes to suspend or expel a student. And furthermore, the Equal Protection Clause protects students from discriminatory treatment by the government. So now if we go forward then, past voucher, to the next slide, voucher program protections. One question that I have thought about in my discussions with parents and with students and advocates is, why should we be concerned? Why should parents, why should students be concerned if there are no protections against religious discrimination, if there's no protection against, there's no provision of constitutional due process. So next slide, please. A non-voucher case called Logadice versus Trustees of Maine Central Institute, I think provides an example of why students should be concerned about due process protection. So this case involves a private school that entered into a contract with a small school district in Maine to educate the district students. In the Northeast, a number of states with a number of school districts that are very small have these types of arrangements with private schools where these private schools provide education to the students in those districts. So in this really strange case, a student had misbehaved, had acted up in several instances. So the school responded, the Maine Central Institute responded to this by basically just suspending that student for 17 days with no due process. It just told the student to leave, and the student was out of school for a very long duration. The student then sued, saying that his constitutional right to due process had been violated because the private school had failed to provide the student with due process. Now, although this was a private school, the private school did have a contract with the public school. So the student argued that that private school had to provide constitutional protections in the same way that a public school would. However, so because of this, there would have been an extensive hearing where the student would have had the opportunity to challenge the assertions, could have possibly brought, since this was a expulsion really more than 10 days, it was a very long time, the student would have had an opportunity maybe to bring in witnesses to challenge the assertions that the school district was making. But the First Circuit found that the student was not entitled to constitutional level due process. Rather, the student was entitled basically to the due process that the school provided, which was slim to none. And the reason why the court reached this decision was because the school was not a public school. So as I've noted here, there are major differences here between the types of rights that the student would have if the student were a public school student versus if the student were a private school student. So this is an important issue to keep in mind. Next slide, please. Now, you might have been paying attention to the news about a big issue that is occurring right now in Indiana and in Florida and in a number of places. And this is the issue of LGBT discrimination. So, a number of states, in Indiana and Florida, we've had a number of instances where LGBT students who wanted to participate in voucher schools were not allowed to. And in fact, in Florida, there was a story of one student or parents who had a student who had one child who had attended attended a private school when that parent was married, when the woman parent was married to a male. However, when she became married, when she remarried a female, when she had a relationship with another woman, that school then responded by refusing admission or enrollment to that student. So we're seeing various examples of this. And students have argued that they are being, they're losing the opportunity to participate in schools that they think may actually meet their needs. They may have educational programming that they find interesting. They may have sports or extracurricular activities. And so they've identified these schools as great schools for them, but they're being excluded from these schools because many participating voucher schools have anti-LGBT policies that will either prohibit them from attending the school if they are LGBT or if their parents are LGBT. So an example of this, and I have a couple of quotes, is Indiana, where a private Christian school principal states that we believe that the Bible clearly teaches that a gay, lesbian lifestyle is contrary to God's commands. And GLBT students and families would not be able to sign an agreement with our statement of faith. So that's one way that they exclude students. And earlier this year, the Orlando Sentinel, a local newspaper in Florida, a Florida newspaper, did an expose in which it found that 83 out of the 1,700 participating voucher schools in its various school voucher programs had LGBT policies. So if these schools were public schools, if this were a public school under the Equal Protection Clause, I think it is we can pretty much assume that this exclusion would violate the Equal Protection Clause. But it is unclear, however, whether voucher schools can discriminate in this manner. Next slide, please. So you may ask, why is it that voucher schools may be able to eschew providing constitutional protections? Well, there is the reason that they may be excluded from having to provide constitutional protections is this concept called the state action doctrine. And the state action doctrine specifically states that the Constitution applies only to the government, but not to private conduct. So therefore, private schools, because they're private actors, will argue that they do not have to comply with the Constitution. But there are exceptions. And so one thing that I have spent this summer with my colleagues Julie Mead and Suzanne Eckes, one thing that we've tried to do is to explore under the state action doctrine whether private schools or participating voucher schools can prohibit students from participating in voucher schools under the state action doctrine. And the title of the article in progress is titled Covenants to Discriminate: How the Anti-LGBT Policies of Participating Private Schools in Voucher Programs Might Violate the State Action Doctrine. Now, I know that's a mouthful, but what we're pursuing, what we're wondering is are there certain arguments that LGBT students and advocates can make if they're going to argue that schools have to provide constitutional rights for students under the state action doctrine. And we found that it's a really difficult argument to make. The Supreme Court in various decisions has made it really difficult to hold a private entity in compliance with the Constitution under the state action doctrine. But one promising argument that we think that we may have is that instead of focusing on the private entity, we think that there may be the possibility, you can say, that the state, through the creation of this voucher mechanism or ESA mechanism, through this creation of this funding mechanism, as you will, are acting in state action by creating a mechanism whereby they enter into arrangements with private schools that they can foresee will lead to discrimination. So it's this creation with the foreseeability that could create that would be state action. So that's one hopeful argument that we think that maybe people can mount to challenge these discriminatory activities. Next slide, please. So, but states don't necessarily have to, be forced to provide the constitutional protections or statutory protections by waiting for lawsuits. They can do this on their own through legislation. So among the recommendations that I would have for legislators is that in addition to racial protections, I believe that voucher programs should require participating schools to address language barriers under the Equal Education Opportunities Act. If voucher programs are designed to provide students with choice, then it needs to provide access for students who may not, who may be foreclosed because of certain barriers, and language is one of them. Furthermore, I would argue that voucher programs should require participating schools to comply with Section 504, ADA, and IDEA. And the reason for this is that, if you're going to have these programs, you should make sure that these students, have access to them. And so, we are seeing instances where voucher schools are not providing access to students with disabilities. And so requiring statutory protection to do so would go a long way to preventing this type of exclusion from occurring. Next slide, please. Finally, I would recommend that voucher programs need to provide constitutional protections for students. So among other things, voucher programs should prohibit participating schools from imposing a religion requirement for admission. Some statutes actually permit this type of discrimination to occur, and I believe that that is problematic. And finally, voucher programs should require participating schools to comply with the 14th Amendment, both equal protection and due process. I think that this is important to ensure that students have access, but the due process protection is important because this is a mechanism that can really help students from receiving arbitrary dismissals. So, this is a good way to ensure that if, in addition, it's not only just allowing students to actually be in the school, but it also provides them with the right to stay in school. So due process protections would go a long way to providing that type of access. So in ending, I thank you so much for attending, and I'm really thankful to have the opportunity to express my concerns, provide recommendations, and I'm really looking forward to talking with you offline, and I'm also looking forward to the questions that come at the end. So thank you so much, and I greatly appreciate it.
Well, we thank you so much, Dr. Green. We appreciate you being here and for all of the information that you shared. We do have a couple of questions that I will ask, but I wanted to just remind everyone first to please submit your questions in the questions and answers box. We would love to have this be a discussion with the attendees as well as Dr. Green. So please enter your questions now. We have one question from Kevin Wellner, who wanted to maybe ask you to clarify just a little bit about the slide that was on statutes and sex and talking about Title IX. And that if you could clarify a little bit more, Title IX does not apply unless the school is a recipient of federal funds.
Right. Well, Title, and Kevin, Title IX, Title IX is, Title IX does provide protections for private, for schools that receive funding. So, so in that regard, a private school, if it receives funds, does have to comply with Title IX, although there is a single, they can still run single-sex schools. But furthermore, there is a religion exemption that applies to Title IX. So therefore, if a school receives, even if a school receives funding, if it's a religious school, then it does not have to comply with the statute. I don't know if I've answered Kevin's question.
I think so, and he can clarify if there's any additional question. Also, we have Ann Hartley, who wanted to know if you could maybe clarify a little bit more the promising argument that if the state creates the ESA funding mechanism and enters into arrangements that they foresee will result in discrimination, they may be held accountable. She wanted to a little more detail.
So under the state action doctrine, what the state action doctrine states that if a public, states that a private school does not have to comply with the Constitution unless there are some exceptions. So there is this concept called the public compulsion test. And under that test, what happens, is that, and this has actually been a major sort of barrier, because what private entities have argued is that they don't have to really do anything because the state statute is quiet on this. So it sort of leaves it to the private entity to do whatever it wants to do. And as a result, they're not being compelled to act. And so what we think, an argument that we think can be made, though, is that within the statute itself, within the funding arrangements itself, the state understands that discrimination is going to occur. And that the state knows that, when it makes these sorts of quasi-partnership, when it enables voucher schools to participate in these, voucher programs, they know that they're going to discriminate. So the state action is in the knowledge that this is going to occur, foreseeing that it could occur, and then not taking any action to prevent it from occurring. So that's the argument that we think could be made with respect to the state action doctrine.
Thank you. And Denise Gomer Hutchinson wants to know, how is it not a violation of the Supreme Court decision in Wisconsin that the money goes with the child, but that's not really true? How can we fight that decision?
Wait, the question again? I'm sorry.
Says, how is it not a violation of the Supreme Court decision in Wisconsin that the money goes with the child? And how can we fight that decision?
That the money goes with the child. So I don't know. I have the liberty of sort of maybe answering the question the way I think it's, how I think it, I understand it. And I think that as I think about the argument, and I think about this not just in terms of student rights, but also in terms of issues of another area that I write a lot about is about financial transparency. And that is that, what happens is that the money follows the child, and that the child then goes to that private school, and then the private school does not have to follow the rules that a public school would have. And for that matter, the money might follow the child, but then that money goes to the private school, and then it's really very difficult for the public to determine how that money is actually being spent. And so the problem that I see is that these approaches, right now, federally, they may actually be permissible, and that's what I think schools are banking on. And so what I've been calling for is for rule changes or, regulatory requirement, at least rules that states can actually create that would make sure that, even if the student takes that voucher and then goes to a private school, that those rights also follow the school, follow that student. So they say that the money follows the child. I would say the rights should follow the child too.
Great point. We have a question from Carol Lenz. If private schools do not have to comply with the Constitution, is that the same for a private business? And I don't know if you have any thoughts about that.
Yeah, I mean, so like, in other words, so if private businesses have contractual arrangements with public entities, do those private businesses have to follow the Constitution? I think that's how I understand the question.
Right, and she's saying, can a business discriminate?
Well, it depends. So let me answer the question this way. So let's say that it is not federal money, but state money. So I guess the question is, would the federal statutes apply to the situation? And so I have to be very careful here because there's maybe some laws that I'm not thinking about. But I would say that I will say that the Constitution would not apply, because the Constitution would not apply under the state action doctrine. There's a good chance that the Constitution would apply under the state action doctrine because, because for instance, the actual contract and the actual provision of money does not make that private entity a state actor for constitutional purposes. So, so therefore, this type of concern that we have for, public students would also comply with private entities. But but I would argue that we should be much more, maybe private entities that are, contracting with the state are, there's a meeting of the minds. So maybe you can argue that they're on equal footing. But when we think about students and parents, there is a power differential. And so we really need to be, because of that power differential, the state, I would argue, needs to step in much more and ensure that parents and students are more protected. So, just relying on possible litigation to provide this protection, I think, is insufficient. States should be actually taking more of a proactive stance to ensure that rights are protected.
We have a question from Arizona, Emily Norton. She says that in Arizona, we have an ESA voucher program that passed this spring that would allow Native students to go out of state to private schools in New Mexico and Utah. And are there any further issues that you could anticipate coming into play for students who are crossing state lines?
I get really concerned by that type of arrangement, I think, because at least within state, you certainly can have more, you can certainly have more control you can draft protections for those students. But once you get across state lines, they may be less likely to think about drafting those protections for students. So I would be very concerned about this. I mean, I would be very, very concerned because it's sort of like, it's the idea that they're going to go out of state lines, but then what happens to those students in those schools? Is the state actually thinking about providing oversight for those students? So I would find, upon first glance, I would be very troubled by that type of arrangement.
From Sherry Wilds, what thoughts do you have about an ESA program that requires parents to sign a waiver of IDEA special ed rights to participate?
I think that's very off. I wouldn't approve of that at all. You know, I think again, and let me back up in thinking about this. This is an example of giving one's rights away, I think. And so, you know, if a student with disability does have, rights that are protected under IDEA. And so, so if you go to a voucher school and those rights are waived, the question becomes, then what happens then if the student gets to that school and then finds that the school is not really making an effort to ensure that that student can access the program? So this again gets to the concern that I said before, where we should not only be thinking about students having access to those schools, but then having the ability to stay there and actually be able to access that program. So this would be another example of the type of arrangement that I would find very troublesome.
Thank you. Monica Murphy asked, how do you propose that we get those rules in place that would require private schools to follow 504 IDEA? And she's saying that in Wisconsin, their legislature is very pro-voucher and is pretty lenient with expectations.
I think, they can write this in statute. They can very easily, simply write this in statute. But again, for that to happen though, I think that parents, advocates, people who are very concerned with this issue have to hit the ground and educate parents about the importance of these concerns. So, by doing that and by pounding the pavement, they may get legislators to be much more concerned about these issues than they already are. So it really would take parental advocacy, civil rights advocacy to go in and really concentrate on this. I have seen examples in the voucher in charter schools where I also write a lot about, where even though charter schools are public schools, they have many of these sorts of instances where they've acted as a private actor would. And so when this does happen, I can point to examples where there have been enough sort of outrage among parents and other civil rights advocates that changes have been made. The primary example of this is in California, where the state actually, after a hue and cry, required charter schools to provide students with the same sort of free speech privileges that public school students had. At one time, it was not clear, but then an instant issue occurred and parents raised their voices and the state legislature responded by correcting it.
And Monica notes that, believe me, we try. So
yeah, there are a lot of, let's face it, there are a lot of, there's entrenched interests who want to keep things as they are.
And please feel free to keep your questions coming. We have a few more minutes on the question and answer session. In the meantime, can you maybe give us a little historical context and talk about the historic importance of governmental protections, things people may not quite understand in terms of the role government plays to protect students and how important that role is?
Sure, I think that you can see this issue with respect to Black students and with respect to students with disabilities. The sort of so we take Brown versus Board of Education, or the issues that led up to the creation of what is now IDEA. There was a lot of, we had lawsuits, you had really a concerted effort to ensure that, that students had access to, that certain different groups of students had access to education. So, you have African-American students, you have students with disabilities. And so there was this sort of, so through through lawsuits and through various efforts, we've gradually gotten at least governmental protections for students. Now I'm going to say, as I point this out, that this is not perfect. We've had a lot of people who've discussed how African Americans are much more likely to be suspended or expelled in public schools. So I'm for one to say that things aren't perfect, but the mechanism is there to correct problems. As I read voucher programs and regulations and rules right now, those protections are not there. So, so when people raise these issues, there's really no way of correcting those problems. So when I say that people may be inadvertently signing their rights away, this is what I mean. They're signing away their rights to have access to education through public schooling that may not be there in private schooling. So they need to be aware of that possible trade-off when they make their decision.
Now, you've mentioned Julie Mead a couple of times, who we were really happy to host as one of our first webinars that folks can check out on our website. And I want to just ask you, you talked about some recommendations as to how to improve some of the situations in private schools. What do you think about the advocates who might say, well, if we go down that sort of reformist route and we work on trying to fix these things, we're going to make it harder to protect our public institutions. And for some of the other reasons that Julie Mead and others talk about, the importance of those public institutions as protecting democracy.
I'm going to say, I should say before going into this that Julie and I talk a lot about this. And so Julie and I are in complete agreement about the need to really prioritize public education. So when I talk about these issues, I should point out that my first concern is prioritizing public education. But if we're going to go in the direction of private education, if we're going to do this, then we have to ensure that that these students have their rights protected in these new settings. So that's kind of like how I think about this first. But let me also talk about this in terms of an area that I did not talk about before in this, in my webinar, but it's something that I do write a lot about. And this is the issue of sort of like funding and the issue of support of public education first. And under state constitutional law, Derek Black, who's a noted education scholar, has pointed out that there is this, that public education is a priority. So if we do these other types of arrangements like vouchers, ESAs, or so on, we must first make sure that public schooling is funded, is protected first before we do any of these other things. So, so when I talk about this, I just want to put this in that framework, that we prioritize public schooling, but that when we do have these other arrangements, we make sure, first of all, that students are protected. And we also make sure, in other research that I talk about, that we have financial accountability, and transparency to make sure that public funds are not wasted or that fraud does not occur.
And I think Denise Hutchinson says, why don't we just shut down private education since the federal government has never met their financial commitments?
It's interesting. It's interesting that you should bring this up because, one issue that Bruce Baker, who's a noted education finance scholar, and I've talked about over the years, and especially in relation to this Espinoza decision, the decision saying that if we're going to have these, if you're going to have private schooling or vouchers for private schooling, you have to include parochial schools. A unintended consequence in certain places, I think, is that you may find certain states beginning to retract from public schools, from funding private schools, if they lose the ability to ensure that, down the line, if they lose the ability to ensure that public education, that certain types of educational approaches or teachings are not able to be restricted due to religion issues, they may just say it's just not worth it. So I think that down the road, as we go through these various attempts to expand voucher programming through the courts, you may see states doing exactly that. They may just say it's just not worth their while to have to deal with these issues that private voucher programs bring up.
One final question that often comes up in these conversations, and probably many people on this call and attendees get, is, for those parents who say the positions that you put forth are devaluing the ability of parents to make decisions, how would you offer that people can respond to that?
I think what's really interesting, when you have to look at this from a regulatory standpoint. And I'm going to use the language right now that gets used about, other privatization contexts. When we talk about parents as consumers. In other regulatory contexts, we have we've learned over the years to have protections for consumers because, otherwise they run into, they can get hurt. Cars blow up. People get poisoned when they take medications. There are protections in place to protect consumers. Now, public education uses the same rhetoric about, consumerism, but in my study, I find that they actually have less protections or fewer protections than in other privatization contexts. So, so that is like very problematic. And so I would say that, so from a regulatory standpoint, I would say that's one reason why I've been calling for these protections. But another reason is that, states have really taken upon themselves, through their constitutions, to provide public systems or educational systems. And with those systems come incumbent protections. And students and parents are, just because of, may not have some of the wisdom, or they may not be prepared to deal with some of these issues. I have taught education law for 25 years. And I can say that there are issues, and I've had issues in my life where I've had to deal with issues and have found that, that I was very concerned. And so this is why we have these protections in place for parents, so that they can advocate for their children. And so these rights make it easier for them to do right by their kids. So those are the reasons why I argue for these protections for students.
Thank you for that. And thank you for this very engaging hour that was so informative and educational to all of us. So we really appreciate you. I do want to let our audience know that our next webinar will be on August 6th at 3 o'clock, and will feature Steve Sweets to discuss his new book, Overturning Brown, on the Segregationist Legacy of Vouchers. So please, again, sign up for emails and you will get the invitation with the full details of that webinar. Thank you all for joining us, and thank you again, Dr. Green.
You're welcome, and thank you so much. I greatly appreciate it.
Take care.